This conference will now be recorded.
Well, good morning, everybody, and welcome to our webinar, which is going to be on wills and powers of attorney. And it's going to be given by Danielle Roberts of Poole Alcock Solicitors. But before we go on to that, what I'd like to do is just run through one or two things first of all. And what I'd like to just read out is our disclaimer, which we normally do at the beginning of every presentation. The following presentation is produced for general guidance only, and professional advice should always be sought before any transaction is undertaken. Individual circumstances can vary, and therefore no responsibility can be accepted by Harts Limited or any of their affiliates for any action taken or any decision made to refrain from action by attendees of this presentation. What we'd like you to do as well, if you could follow us on LinkedIn, that would be fantastic. You'll get details of all the stuff which we send out on a daily basis, and updates and information on future events and so on. And again, please subscribe to us on YouTube. We have our YouTube channel out there, of which this webinar will be appearing, but we also have some videos which are being released. There's 2 released so far, there's another 3 to come, so watch out for those on various topics. And again, please follow us on Twitter as Harts Accountants. A quick government support update. Not much has changed since we did the webinar a couple of weeks ago. Just a reminder that the furlough scheme ends at the end of this month, so we've got to make some decisions on employment. The VAT in hospitality again rises to 12.5% from the end of this month, and we have the recovery loan scheme in place with loans now available for this. We also have the national insurance rise coming in from April 22, with a lot of that in the press as well. So just watch out for that, and you need to build that into your planning and to your cash flows and so on. What I'd like to do is just push our next big event, which is on the 7th of October, which is our question time drinks reception, which is going to be held at Macclesfield Football Club. This is our in-person event. We've got a great panel which you can ask your questions to. So we have Mr. Paul Griffiths, who's the chairman of the monastery and St Francis and Gorton Trust. It's that fabulous building in Gorton. If you've never been there, it's well worth a visit. He's also the Deputy Lieutenant of Greater Manchester and an ex-director of the ASDA and the Co-op. We have Tommy Taylor, who is a professional rugby player for now Sale Sharks and England. Those of you who know David from here will know that this is his son, so it should be very interesting insight into the world of professional rugby. Kay Stevenson, who's from Macclesfield Mean Business, promoting businesses in Macclesfield. And Nick Bianchi, and I'm sure all of you have heard of Origi Bianchi. Well, he's director of Origi Bianchi. So again, book your place. It's a free drinks reception, complimentary drinks and snacks. And if you can get your questions into our panel by the 6th of October, which is just the day before, then that will be fantastic, and we can get everyone's opinion on what current situations are and current events and so on. And again, please contact us or contact Nina or myself, and we'll get you booked on. So we also have on the 21st of October, we're going to be doing an online event on cybersecurity, and our seminar program has changed because we now have a budget which has been announced. So budget day is 27th of October, and we're going to hold our update on the 4th of November. So that gives us a lot of time to assess what's in that budget, whatever is in there, and give you the full detailed analysis rather than just doing it the day after, whereby we might not have all the details. What you often find is the details come out in the small print a bit later on. So that's me done. What I'm going to do is going to make Danielle the presenter, and so Danielle, it's now over to you. You should be able to now present your PowerPoint presentation, and you can talk to us all about wills and powers of attorney and what we should be doing, what we shouldn't be doing, and hopefully we should be able to get cracking. What will be interesting to know, though, is before we actually do that, if we've got the chat box here, which is a speech bubble in the top right-hand corner of your screen. What I'd like to do is just do a quick straw poll. Have you done a will? Yes or no? If you could just put yes or no in the box, that would be great. And a second question is, have you updated your will recently? And then put a yes or no in the box. And the third question is, have you got a power of attorney? And this is very important in relation to potentially care home fees and all the rest of it, which I'm sure Daniel's going to actually touch on. So over to you, Danielle.
Thank you, Stephen. Good morning, everyone. Just by way of an update, I'm hoping this is going to work. So can everyone see my screen? I'm hoping so.
Yes.
Perfect. That's one battle over. Right. So basically, just going to do a bit of an introduction on what we're going to do. So these are the main things that I'm going to talk about today. So I've got lasting powers of attorney and wills, as Stephen set out. I've also put in a little bit on court of protection, just as sort of an aside to powers of attorney, just to sort of show you what the options are if you don't have one. Not a lot of people know what route to take if somebody's already lost capacity and there's no power of attorney in place. So I've put that in as an aside, just as a bit of guidance on there.
Can I just quick interruption there? Just looking at the results of the poll, it seems that some people have wills, but not many have updated it, and not many have powers of attorney at all. So just thought I'd give you that quick update.
Perfect. So at least people are going to get a bit of useful information, hopefully, out of this. Well done to those of you that have got wills already. That is a good place to start. Obviously, keeping them up to date is important as well. Circumstances change. We tend to advise people to review them every 2 to 3 years, or when you've had a big life event, marriage, children, divorce, inheritance, things like that, just to make sure that it's now suitable for your current circumstances. Just before I get started, I just wanted to basically introduce who I am and where I'm from. So I'm Danielle Roberts. You'll come to me in a second. There's a little bit on your screen about Poole Woolcock. So we're a full service law firm. We've got over 100 years quality practice across varying areas. And we've got offices that cover 6 towns across Cheshire. But we also have further satellite offices that provide national coverage. So really, we're able to sort of reach out to most of the country and being able to guide people in the right direction. That's me. Not the best photo. Much prefer the one on your screen. But there you are. I'm based in Congleton in Cheshire. But like I say, we do have staff that cover broadly across Cheshire anyway. So one of the team would be able to help you. So, getting started then, lasting powers of attorney. It seems to be that this is going to be an important one, given that not many people have got them in place. So, just doing some key facts on powers of attorney and trying to give you sort of a broad spectrum of information. Obviously, you know, if you've got specific circumstances that need advice, then it's definitely worth going and getting it before it's too late. I think that's one thing that I try and hammer home to people on power of attorney is they're a bit like an insurance policy. You hope you never have to use them, but you would always prefer to have it there in the background just in case. And what I mean by that is that you can only set up a power of attorney whilst you still have the mental capacity to do so. So if, you know, a lot of people leave them because they think, oh, I don't need any help or I don't need any assistance right now. I'll do that when something happens that means that I need it. Now, waiting until that's when something happens means that you could leave it too late and therefore be without any kind of protection. So it's something that you should set up now in readiness. Get it up, get it set up, get it registered, put it away in a drawer, put it in your safe, leave it with your solicitor. It's there when you need it then. So basically we have a power of attorney versus court of protection system. So power of attorney, if you've got that set up and somebody loses capacity, so let's say you have that set up for your parent and then they lose capacity, you can then go on to use that to assist them in their sort of future care and future finances and things like that. If you don't have that set up already, the only option left open to you if that person has already lost capacity is to go down a court of protection route for a deputyship order, which I will come on to shortly. So there are two different types of power of attorney, or rather, there are two different standards of power of attorney. There's an enduring power of attorney, which I'm sure many of you have heard of, which always used to be the one that you could put in place prior to 2007. Now, after 2007, you couldn't make enduring powers of attorney anymore. They brought in lasting powers of attorney. Now, I'll go through the difference in a second. But one important thing to note is if you or somebody you know has an enduring power of attorney, don't panic, and that's not to say that they're not still valid. They may need updating because, 2007 is quite a while ago now. It's worth having a review of them and seeing if they cover everything you want them to, and also if the people that you appointed are still the right people that you want involved. But in theory, they are still valid. You can still use them. So there's no need to panic that what you've got is outdated or anything like that. Now, the main difference between the two is that an enduring power of attorney only covers property and financial affairs. It doesn't cover health decisions or care decisions, whereas the lasting powers of attorney, they've brought in separate documents to do that. Now, the enduring power of attorney, again, is made when somebody still has capacity, but in theory shouldn't be registered until that person has lost capacity. So it should basically be sat waiting until such time as it is needed to be used before it is registered with the court and then able to be used by the attorneys. It is the main difference between that and a lasting power of attorney. Lasting powers of attorney that you make now are registered at the time you make them. You can choose not to, but most people do. Just so that you can use it straight away when it's necessary, basically. An enduring power of attorney is able to be used once it's registered, but that can take some time, and that was one of the main downsides and one of the main reasons that they brought in lasting powers of attorney. So if you've got an enduring power of attorney or you're appointed under one, it's best to double check, like I say, that it's still suitable for your needs. And if it is, that's fine, you can carry on, but it's something to be made aware of that you will need to register it before it can be used. Lasting powers of attorney then came in 2007, and they do everything that you think that they do. There's two different types. So there's a property and financial affairs one, and there's a health and welfare one, which I'll go through in more detail in a second. But in effect, they are registered at the time you make them, unless you choose not to, which makes them much more practical for your attorneys to use going forward. They can simply pick it up and go and use it as and when they need to, as opposed to having to wait for it to be registered at a time when things may already be quite difficult. Loss of capacity, just before I move on to the different types, loss of capacity can raise some questions as to exactly what that means. So it's a grey area and it needs to be dealt with delicately. So somebody doesn't usually just lose capacity overnight. So usually there will be a decline in somebody's ability to make decisions or weigh up decisions for themselves, and they'll need some assistance in everyday tasks. It can be the case that capacity disappears very suddenly, but that is hopefully few and far between. But if in doubt on somebody's capacity, it's always best to get the opinion of a medical professional, whether that be GP, specialist, or indeed sometimes social workers can make decisions on that as well. Now, for the majority of people, the person who has made the power of attorney will appreciate that they need some assistance before they lose capacity, and they'll be able to sort of indicate that they'd like you to help them with their finances or things like that. Some people are fiercely independent and will not let you assist them until such time as the capacity is gone, and that can be difficult because they might think that they still have capacity to deal with these things, but they may not be able to weigh up all the necessary decisions and factors in making important decisions, especially around finances and things like that, where there's so much to consider. So it may be that you have to seek the advice of a professional, but hopefully most people can work together on these things going forward. So just moving on then, like I said, there are two types of powers of attorney. There's the first one that we'll go through is financial decisions, which basically does what it says on the tin. So that will help you to assist the person making the power of attorney manage their finances, so access bank accounts or building society accounts, manage investments, buy, sell shares, basically anything financial. It can even assist in dealing with things like paying bills or speaking to companies over the phone. We've all been in that situation where you're trying to assist somebody that perhaps can't hear very well over the phone, but they won't let you speak to them because you're not the account holder. It can get very frustrating for you, for the person you're trying to help, and I suppose for the person on the phone as well. But if you can register a power of attorney for somebody with that company, then you can manage those accounts by yourself. You can also collect benefits or a pension on behalf of that person, although there are ways around that. If that is the only financial concern that you're having to deal with, there are ways around that without a power of attorney, but it is certainly easiest to have a power of attorney in place. Something else that you're able to do with a power of attorney is selling your home and or purchasing a replacement. So obviously there are quite big things that an attorney is able to do, so it's certainly important that you trust them. But it does allow you to appoint attorneys to manage big decisions that you would otherwise have dealt with yourself, to be able to do those on your behalf. So you're going to be looked after basically. And it's important that this is in place because if you go into care or you need care at home, obviously that's got to be paid for. Now, if you don't have a power of attorney and everything is locked up in somebody else's finances and you can't go and access them, then there's going to be a big problem, which is where the Court of Protection comes in. But as you'll see momentarily, that is a long process, an expensive process. So this is the much easier way of going about things. As I said, there's also a health power of attorney. Now, this is the big introduction from the enduring powers of attorney. These didn't exist under enduring powers of attorney, but came in under the lasting powers of attorney. They are separate documents, so you can only do a financial one if you prefer, or you can only do a health one if you prefer. A lot of people choose to do both, so that no matter what the decision is needing to be made, somebody can do that for you. So, I mean, a health LPA, again, does what it says on the tin, really. It allows your attorneys to make decisions as to simple things like daily routine, so making sure that you're clean and washed and dressed and that you're eating the same diet as you did before. Might not seem important to everyone, but these are big things to some people. Right through to medical care, being involved in appointments and things like that, and being able to access test results and things. Right up to moving into a care home, whether that's something that needs to be done or something that you feel strongly about having care at home, then somebody can speak on your behalf. Right through to things like life-sustaining treatment. So there's a specific section on the form which allows you to give your attorneys the power to make decisions on life-sustaining treatment or not. You don't have to. I personally think it's the biggest part of the form. If you're going to put a health power of attorney in place, then this is the reason to do it. You know, if you're unconscious or, you know, you have otherwise lost capacity and a decision needs to be made about life-sustaining treatment, then you would be hopeful that the attorneys would make a decision that you would be happy with. They can consent to or refuse treatment on your behalf as long as they know your wishes, and that's the most important thing with this, is that yes, they have the power to do these things, but they need to know what your wishes are in terms of making decisions that you would be happy with. Now, one of the important things to note with a health power of attorney, as opposed to a financial power of attorney, is that a health one can only be used by your attorneys once you have lost capacity. So as long as you have capacity, and doctors obviously would be involved in this, as long as you have capacity, you can make decisions for yourself and your attorneys cannot overrule you. They cannot force you to go into a care home, they cannot force you to have treatment that you don't want. Up until the point where you don't have capacity for yourself, and that's when attorneys can step in and make those decisions. A lot of people worry that putting these in place means that their kids are just going to stick them in a home and not manage anything for them, but that's simply not the case. Whereby you have the ability to make decisions and be involved in important decisions, then you will be. Nobody is going to take that away from you. So a quick overview on the process of making a power of attorney. Firstly, you need to decide who to ask. And as I said before, these people need to be trusted. They have a lot of power to make important decisions, both in respect of personal welfare and finances. There's going to be access to all sorts of funds, all sorts of property. You need to be able to trust them and make sure that they're going to make decisions that you're happy with. The attorneys have to be over 18, but they don't have to have any special qualifications, and they don't have to be related to you. So you can have friends, neighbours, work colleagues. Most people do choose to have family, but obviously not everyone has close family that they can turn to. So there is a wide scope on who you can appoint. Importantly, those people have to accept that they're going to be a power of attorney. They have to sign the paperwork because it's a lot to take on and a lot of responsibility. So it's best to have a chat with them beforehand to make sure they're happy to take that on. Completing the forms, it's something you can do yourselves. Obviously, we would advise you go and have a chat with a solicitor about it. Simply because there are lots of different aspects that need to be taken into consideration. There's lots of possible pitfalls on the forms. They have to be signed in a certain way. So it's always best to seek some professional advice when completing the paperwork. Now, you can have up to 4 attorneys and 4 substitute attorneys at any one time. Whether you want that many people involved in your decisions is left entirely with you. But that's the kind of advice that you can take from a solicitor when you set these things up. You also have to have something called a certificate provider, which is somebody that signs off on the paperwork to say that you have the relevant capacity and that you also aren't being influenced by somebody else to put these things in place. So somebody will assess that separately. Now, if you do that through a solicitor, quite often they will sign that off for you, having done those assessments as part of the instruction. You can also have somebody such as a GP or a close friend that's known you for over 2 years sign that paperwork off. Once the forms are complete and signed in the appropriate way, they then go off for registration with the court. There's an objection period with the court of 4 weeks, so that if this was being done fraudulently or you changed your mind, you can get in touch with them and cancel the whole application. Once that objection period has passed, they will then be registered by the court and returned either to you or your solicitor registered. So they are then ready to be used. When the time comes that you may need to use a power of attorney, you will need to then register the forms with the relevant institutions. So for financial power of attorney, that could be with the bank or the investment company or the share registrar. It could be with a solicitor for selling property and things like that. But also for health, you may want to register it with a GP or hospital, depending on the situation. it's quite likely that they may ask you if you're in a hospital environment if you've got one set up, and that'll obviously twig you to go and get the paperwork. Registering the forms, you will basically need to provide proof that you are an attorney, proof of address, proof of ID. But once that's set up, you'll be given access to accounts and cards and things like that, and then you'll be able to use the finances much as you do your own. Obviously, there are responsibilities on you to use the funds for the benefit of the person making the power of attorney. And you can be reported to the court if people think that things have gone awry. So it's always best to keep some records of what you're doing, just in case anyone ever raised any questions, you'll be able to back that up.
Danielle, we've just had one question come in so far, and can you have multiple levels named in the LPA? For instance, your first wife, first your wife, not your first wife, first your wife, but if they are not able, then your child?
Yes, you can. So you can have, as I said, you can have primary attorneys and you can have replacement attorneys. Now, you can have several, well, you can have up to 4 primary attorneys and 4 substitute attorneys. The substitutes only come in when there are no primary attorneys left. So you could have your wife as a primary attorney, and then if there's a situation whereby she can't act anymore, or let's say she's passed away, if the children are appointed as substitute attorneys, then they can step in and take over. So yes, you can have different levels. It's important to consider how you want to appoint people, because it depends on whether they can help straight away or whether they can only help sort of at a later date if there's no primary attorneys left. But yes, certainly there are ways and means of having different levels of people appointed.
Great.
Okay, so just to finalise then, there are restrictions on powers of attorney, or rather you can put restrictions on use of powers of attorney. So you can put in instructions or advisories to your attorneys on how you would want things managed, and what you would like them to do. So let's say you had specific investments, you could say that those investments had to be dealt with by a certain financial advisor or things like that. What we tend to advise people is try not to make the power of attorney too restrictive. Once these documents are registered, it's difficult to change them without having to do complete new ones, which obviously can be expensive. So we advise people to try and leave the instructions or advisories out of the forms themselves, and to have sort of an accompanying document with the powers of attorney. Obviously, if it's something that you feel very strongly about, then by all means put those in. It's just that they can be very restrictive sometimes on the use, and obviously the attorneys just want to act in your best interest. So give them the widest scope possible is useful, really. So I will probably move on to court of protection, unless there's sort of any burning questions on power of attorney.
If anyone's got anything, just shout out, unmute yourself. We are getting a little bit of background feedback, so can you just keep the noise down in the background? I'm not sure who it is. But if you've got any questions, feel free to shout out, unmute yourself, or stick it in the chat box.
Okay, I'll carry on unless we get anybody shout out.
Sure.
So, court of protection, I've touched on it briefly. It is quite complicated. So if you find yourself in a situation whereby you need some advice on court of protection or a deputyship order, then I really would encourage you to get some legal advice, just to make sure that it's dealt with properly. But just to give you a bit of an overview, because it can be quite scary if somebody has lost capacity and there's no power of attorney in place, or the power of attorney isn't suitable anymore. So just to give you a bit of a background, really. A court of protection order, so a deputyship order, is applied for when a person can't make decisions or manage their own affairs anymore, and there's no power of attorney in place, like I say. It's a court order that appoints somebody to become a deputy and manage that person's affairs. Once it's set up, it is very similar to a power of attorney, and the deputy has the same responsibilities, the same powers to be able to manage finances and things like that. It is quite rare for a deputy to be appointed for health and welfare, and it tends to be only in emergency situations. So if you have a burning desire for somebody to be able to make decisions on your health and welfare, then it's important to do a power of attorney to make sure that that can be done. It's not guaranteed through court of protection by any stretch of the imagination. What comes with court of protection that doesn't come with an LPA is a greater level of responsibility. So obviously, as an attorney under a power of attorney, there is a high level of responsibility, of course. However, there is no requirement to account to the court in the same way that there is with a court of protection order. With the court of protection order, you have to file annual accounts to the court to detail what has been spent, how it's been managed, why these funds were needed and things like that. So it can be quite onerous in order to manage that. The court has the power to sort of intervene at any point, and they do oversee the application throughout that person's lifetime. So it is quite a hefty responsibility that comes with a court of protection order. It is also much more restrictive than a power of attorney, in so much as a lot of decisions, especially around sale of property or purchase of property, and similar with investments, you will need permission from the court of protection to make decisions such as those, to make sure that they're using the person's funds in the right way and in an appropriate manner. So it can be, like I say, quite time consuming, quite onerous, and really quite a big responsibility to take on. However, sometimes it's necessary. If something's happened where capacity has been lost unexpectedly, perhaps through some kind of accident, or somebody's had a condition that's developed very quickly, then this might be the only option left open to you. And whilst I say that it's a big responsibility and it can be very time consuming and things like that, it is important to do it if it's needed. It may be that somebody has to go into care and doesn't have a power of attorney set up for finance. Well, those care fees have got to be paid somehow. So you will have to apply to a court of protection to become a deputy and manage the financial affairs of that person. So in terms of a brief overview of the process, it can be quite scary when I say that you have to go to the court of protection for this application. It is usually a paper application. There's usually no requirement to go and attend a hearing with a judge. That being said, it can be requested if the particular application requires it, if there are unusual aspects to it. It's not a definite that you won't have to go to court, but it is very unusual. So it is not quite as scary as it sounds. There's a lot of it done on paper. That being said, there are a lot of forms to fill out, one of which is a assessment of capacity that has to be done by a GP or other medical professional or member of social services with the relevant qualifications, just to stipulate that the person concerned no longer has capacity and doesn't have the ability to make decisions for themselves. Obviously, this order being put in place is very restrictive on somebody's rights and ability to manage their own affairs, so they have to be sure that that person isn't able to do that for themselves. So you do have to get that filled out. There are various application forms for the person applying to be a deputy or people applying to be a deputy. You have to be assessed by the court to make sure you're a fit and proper person to manage that person's affairs. Obviously, they're giving you, again, a great responsibility on managing funds and finances, so they want to be sure that you're not going to run off and go on a worldwide cruise and things like that with that person's money. So it's important that they assess you. They also have various fees in place, so this is a more expensive process than a power of attorney. And with a power of attorney, you only have to pay a small registration fee with the court. With a court of protection hearing, with a court of protection application, there are application fees, there are assessment fees, there are fees for getting the capacity assessment taken out. There are ongoing insurance costs and review costs with the court that are payable on an annual basis. So it is much more expensive, but like I say, sometimes it's the only option left, which is the real reason I put this in. It stresses the importance of having a power of attorney.
Another question which has come in, Danielle, is if more than one attorney is appointed, how is a difference of opinion between them over how the power is best applied resolved?
So it depends very much on how the attorneys are appointed. So you can appoint attorneys jointly or jointly and severally. We would always advise people to have it jointly and severally, simply because it's the most flexible way of having people appointed. Mainly because if one person can't act for any reason, the remaining attorneys can continue to act. But you can appoint people jointly if you really feel it's necessary, which means they have to agree on every decision. If you have a difference of opinion, what you will need to do as attorneys is seek some independent advice, whether that be from a financial advisor if it's to do with finances or investments and things like that, or whether that be from an estate agent if it's perhaps on accepting different offers on a property, or indeed if it's on a welfare issue, then from social worker, medical professional, basically somebody with the requisite knowledge to sort of intervene and give the best advice on what is to happen next. So that's what will need to happen. There are ways and means of if a decision cannot be made, then you would probably need to go down a court of protection route to get the court to decide. Obviously, if you've paid to put a power of attorney in place, you really don't want that to happen. So it's an important thing to consider when appointing attorneys, to make sure that they're likely to be on the same page. Obviously, there are going to be differences of opinion on certain matters, but if you've got two children that you know absolutely do not get on, then you're perhaps either worth considering only having one of them, or if you're desperate to have both of them, put also a third party on there so that there's another person to make the decision alongside them. So there are ways and means of going about getting sort of a third opinion, but it's worth always speaking to a professional to get a bit of advice on that particular matter. So just going back to court of protection, I've gone back. I want to go back one. Okay, so there is a requirement once you've filled all your forms out and submitted them to the court. You then have to serve the application and notify other family members that that application has been put in. So there's a requirement to serve it on the person to whom the application relates. So, you know, if that's your parent, you have to notify them that that's been done. There's every chance they will not understand or comprehend or be able to give any opinion on that being done if they've lost capacity, but you have to do it anyway, and there's certain forms that you have to fill out to say that that's been done. The notification element to various family members is simply so that people have the right to object if they think something is being done underhand or somebody's not suitable to take on that role. Hopefully nobody does do that and the application can progress. You then have a consideration period by the Court of Protection. They may come back to you with requests for further information or requests on certain elements of the application, and you have to comply with those until the court is happy to progress the application. Once they are happy, you are then provided with information on putting what's called a security bond in place. Now, this is one of those things that has to be put in place each year, It is basically an insurance policy to protect the finances of the person to whom the application relates. Now, that is no reflection on the person that's being appointed, on their integrity or anything like that. It's just the court has to put this insurance in place to cover the eventuality of something underhand going on, and money's being taken, so that those monies can be replaced if something did happen. So that it's basically, like I say, an insurance policy that is renewed each year, and there's a supervision requirement from the Court of Protection that has to be complied with as well before the order can be made available. Now, once that order is available, you can then go on and register it with the various institutions as you can with a power of attorney. So from there on in, it works in much the same way, apart from the accounting requirement, which I touched on before, which has to be done each year. So that is a brief overview on Court of Protection. That is quite a complicated area, which is why I've tried to keep it quite brief. So if you, like I say, if you have any specific queries on Court of Protection, the process of that, or whether it's needed for your particular circumstances, like I say, it is best to get some legal advice on it to see if that's the route that you need to go down. If there's any questions on that, again, feel free to shout out and I can go through those with you. Okay. So I'll move on to wills. There's quite a bit to go through on wills. Now, a lot of you said that you had wills in place, but they hadn't potentially been reviewed in the recent past. It is important to review them, mainly because they could have been written some time ago. Your circumstances could have changed a lot. It may be that they were very simple wills and in fact still reflect what you want to happen, and that's absolutely fine. There's no time period on which a will should be updated, but it's just worth keeping an eye on sort of every 2 to 3 years, or like I said before, when certain life events happen, just to make sure that it's still suitable for your needs. Now, the first thing I'm going to go through is intestacy, and this is covering what happens when somebody dies without a will. Now, it's more of an information process in the hope that a lot of you that haven't got wills will think about making them. There's a lot of things that people don't realise. People think it'll all be straightforward if you don't have a will. Your family situation might be very simple, but it's not always the case. So the first thing that people automatically assume is that, right, I'm married to my husband or wife, everything that I have will pass to them. That's not necessarily the case. It very much depends on the value of your estate. So where somebody doesn't have a will, the intestacy rules apply, and that means that the first £250,000 of your estate will pass to your spouse. Anything over and above that is dealt with separately. So if your estate is under £250,000, then yes, it might all go to spouse. It will still be easier with a will, but it would go to your spouse. However, if you're over and above that, which, let's face it, by the time you've got property and perhaps some bits of investments or inheritance from other family members, you could be up and around that amount. Anything over and above the 250 is then dependent on whether you have children. So if you have children, half of the amount over 250 will go to them, and the other half will go to your spouse. If you don't have children, it would come back to your spouse anyway. It can get quite complicated, is what I'm trying to point out. So again, it's best to have a will in place to dictate where you want it to go and things like that. It can get especially complicated whereby either you have unmarried partners, which I'll just come back to that in a second, or if indeed you have a second marriage. Obviously, you may have children from your first marriage, so it may be that being married a second time means that everything automatically passes to your second wife or second husband, making sure that nothing then passes to your children. Or indeed, it could be that you want everything to pass to your husband or wife, but not everything does, because you're over the threshold, and then that can cause some problems between children that may not get on with step parents and things like that. Again, so if you've got a situation whereby you've got children from other previous relationships and things like that, it is certainly worth having a will in place just to protect everybody that you want to be protected. That would include unmarried partners. Unmarried partners are not included in the intestacy rules, so will not inherit a thing. It doesn't matter how long you've been together. It doesn't matter if you have children together. If you are not married, you are not legally entitled to inherit from somebody's estate. That being said, if you have joint assets, so if you jointly own a property with your unmarried partner or have a joint bank account with your unmarried partner, those assets would still pass to the joint account holder or joint owner of the property, but that is it. Everything else would pass via the intestacy rules, which obviously can make life very difficult. It does affect a lot of people these days, with less people choosing to get married. So it is important to consider what happens if that is something that affects you. It's important to consider as well the aspect of biological children and legal children, so adopted children versus stepchildren. So it may be that you want to, you have children of your own, but you also have stepchildren from your partner's previous relationships. And it may be that you want everything to just be divided between all of them. You might have a good relationship and want everything to be divided equally. That will only really happen if you have a will, because when it comes down to the intestacy rules, if your estate is to pass to your children, it will only include your children that are biologically your children or children that you have legally adopted. So if you just have stepchildren by virtue of the fact you have married their parent, they will not be included, and that can be really, really difficult, whereby those children have all been brought up together. And you may have inherited their parents' assets. It can get very messy. So the easiest way to cover this is with a will. In the same way, there may be family members that you don't want to inherit. So, unfortunately, it is often the case that clients come into me and say, we've got 3 children, but we don't have anything to do with one of them. We've been estranged for a long time. We don't have any relationship with them. We don't want them to inherit from our estate. And that's fine. You have the freedom to do that. But if you don't make a will, that person is going to be entitled much in the same way as the children that you do want to inherit. So instead of your estate then going 2 ways between the children that you want to inherit, it's going to go 3 ways and include the people that you don't want to inherit as well. So that again can get very messy. It can include children that perhaps have come from previous relationships that you've never unfortunately had a relationship with. So it can include everybody, and it can cause many arguments. So it's something that if you feel strongly about disinheriting somebody, then it's important that you make a will to cover that. Finally, one other consideration to make on intestacy is if there are no legal relatives that can be found for somebody, their estate passes to the Crown, so it goes to the government. Now, it may be that you don't have any family that you wish to leave your estate to, but you might have friends or neighbours that have looked after you that you want to leave it to. It may be that you have charities that you want to leave it to. A lot of people feel very strongly about their estate passing back to the government. So the only way to avoid that, like I say, is to make a will. There are tax consequences as well that come from that. So it may be that your estate can be subject to inheritance tax. If you leave it to charity, it would be exempt from inheritance tax. So there are other things to consider from the intestacy rules as well, which is the real sort of plug to go and have a chat about a will or review the will that you've got. It can get very messy if that will isn't suitable for your needs. So just a brief overview then of what's in a will.
Can I just jump in? We're running a little bit over, so we've got about a few minutes. If anyone needs to leave, just shout. But I think if everyone wants to stay for the next few minutes, that'll be fine.
Yeah, no problem. Lovely. So I'll give a brief overview of this, and I'll just move on to the bigger bits. So I think I've covered most of the testamentary freedom element on the intestacy side. Just basically, a will gives you the choice to do what you wish. There are things that you have to consider, of course, but you are able to make a decision based yourself on what you want and not what anybody else wants. So if you want to leave everything to the dog's home, you can leave everything to the dog's home. So it's the only way of securing what you want to do. Other things to consider: you need to appoint executors to manage your will. They need to be over 18. A lot of people worry that if somebody is an executor, they can't also be a beneficiary, but that's not true. So if you want to have your children as your executors, you can do, and they will still be able to inherit under the estate. It's also important to consider guardians. If you've got children that are under 18, you can appoint them to act in the absence of any other legal guardian. So if both parents have passed away, then there's somebody that can be considered as a guardian. You also just need to consider what you want to happen to your estate. So do you want to leave specific gifts or legacies to certain people or to charities, etc.? Are you happy for everything to be put in the one big residue pot and split between your beneficiaries? It's important to have a think about what assets you've got and how you want them to be dealt with and who you want to have them. So it's just worthwhile having a think about what you've got, where you want it to go, and who you want to be involved. With wills, there's also various other benefits, tax planning being one of them. It means it's something that you can do in advance. So you can have control over the inheritance tax situation on your estate. You can look to plan for that and see how best to manage any tax liability whilst making the most of things for your beneficiaries. You can also get advice on trusts and how best to protect assets for either vulnerable beneficiaries or protecting assets against care fees if that is a concern to you. Consequences of disinheriting, we've already touched on mostly, but it's always worth considering what those consequences could be. People will have the right to challenge your estate, so it's important to show that you've considered the rights of those that may have been entitled, and there are things that you can do if you seek legal advice on protecting as best as you can against that. You can also include funeral wishes in your will. They aren't legally binding, but it's the first place a lot of people look if they're not certain what somebody wants, so it can be an important aspect to include. Now, just briefly before we do end, a lot of people are wanting to know what they can do to protect their estate against future care, and there are various things that you should consider. So a lot of people want a simple will, and that is great, that is fine. I advise people try and keep it as simple as you can. Overcomplicating it makes it difficult for executors. However, there can be downsides. If you leave everything to each other, if the remaining person then needs to go into care, then all of those assets could be used to pay for care fees, which a lot of people obviously don't want. They want to be able to protect something for future generations. However, a lot of people come in and say, oh, can I sign over my investments to my children now? Can I sign over my property now? The answer in theory is yes, you can, but social services or the local authority will always look to see if you've deprived yourself of assets on a permanent basis to avoid paying care costs, and they can look back and include those if they think you have done that in any financial assessment. So it's important to try and manage as best you can the assets that you do have and protect them as much as you can, whilst also bearing in mind that you can't be seen to be giving assets away to avoid paying care fees in the future. One of the most advised ways of doing that is something called a life interest trust, and that is something that's included in your will that helps protect your property as best you can against being used for care fees. So if you own a property jointly with your husband or wife or your partner, you most likely own it as something called joint tenants, and what that means is that automatically upon death the property will pass to the surviving joint owner, and that will then become theirs solely. That can be very simple, but also be problematic if that surviving owner then needs to go into care. The whole value of that property can be used to pay for their care fees. You can change that to another form of joint ownership called tenants in common, which basically splits your ownership down the middle. So assumes 50-50, you can change that if you want to, but let's go with 50-50 for now. And it means that you can leave your 50% in your will to who you like. Now, you will always want to protect the other joint owner and their right to live there, so you can put it in this life interest trust that allows the surviving person to live their full life without the threat of being kicked out or charged rent or anything like that. They got all the bad bits of making sure they pay all the bills and keep everything in repair and things like that, but you'd have to do that anyway. But you can protect it whilst ring fencing your share of the property under the trust for your beneficiaries. For example, you could say that you allow your husband or wife to live there for the remainder of their lifetime whilst holding the property on trust for your children. Now, what that means is if that your surviving spouse then needs to go into care, they only own their own 50% of the property. The other 50%, your 50%, is owned by the trust, and that is protected, so it can't be used to pay for their care fees. It is ring fenced for the beneficiaries of the trust, which might be your children. It is flexible. There are terms written into it that allow for the surviving spouse to sell the property and move to another one and things like that. So there are ways and means that you can carry on as normal. It's not as restrictive as people worry it might be, but it does offer you the protection that you need for trying to ring fence a little bit of something for the next generation. Now, it's not a permanent or a prolific way to avoid care costs. It won't work if you own a house in your sole name. That unfortunately is your asset and your asset alone. So there's not much you can do in terms of life interest trust with a house in a sole name. You would have to see if you can leave that another way to a beneficiary. But if you go into care yourself, the chances are that property is going to be used for your care fees. It also doesn't work properly if both owners need to go into care. If you both need to go into care in your lifetime and your full 50% value is used, then the whole value of that property is going to go. But it's the safest way that you can try and ring fence something. The chances of you both going into care and both using your whole entitlement are relatively small, not impossible, but relatively small, and therefore it is the most useful way to plan ahead right now. There are requirements for life interest trusts to be reported to Hmrc upon the first person's death, just to note with them that that trust exists, and you're able to get further advice from that from accountants or Hmrc themselves. The final bit that I just wanted to try and squeeze in, if there's time, is for discretionary or disabled persons trusts.
We'll be very brief on this one, please. Yeah. Thank you.
Yeah, no problem. Basically, some people have beneficiaries that they wish to protect, vulnerable beneficiaries. So you might have a disabled child or a disabled family member that you want to protect. Now, they may not be able to manage funds for themselves, so you are able to set up a trust to protect them and their interests. Your trustees would be in charge of the funds within the trust, and that can include your home. It just means that they can look after the money for that vulnerable beneficiary and make sure that it's used in the right way. They're not vulnerable to third-party influence in the same way as the beneficiary themselves might be, and they're able to make sure that it doesn't impact on state benefits and things that they might be entitled to, whereas a capital outright to them obviously might cause a problem. You can put your entire estate into a disabled person's trust or a discretionary trust, or you can put just part of it. If you have other beneficiaries that you're happy to receive monies outright, then they can go straight away. I think really if you have any questions on disabled persons trust or discretionary trusts, it is best to get some legal advice. They can be quite sensitive, obviously, by the nature of them. So it's worth having a chat with somebody about setting those up and being able to do right and do the best thing by your beneficiaries. They can be beneficial for tax purposes and things like that as well. So it is important that you get some advice on that. I think that's probably where I'll leave it for now. Obviously, if anybody has any questions, I'm happy to answer those. Obviously, you've got my, or Stephen has my contact details. If anyone wants to get in touch for further information, I'll be happy to assist with that. I hope that was informative and I've not thrown too much information at you for a Thursday morning. Hopefully that's covered a lot of issues that people had got questions about.
I've just got a couple of quick ones. How far back can social services go looking at financial records?
It is a very grey area. It is indefinite. I always say the further back something is, the less likely it is that they're going to worry about it, but there is no restriction on time. So it's not the same as inheritance tax rules, which have a 7-year period. They can go back as long as they want if they think something has been done. So unfortunately, there's no definitive period on that one.
Okay, and the final question we have is, are there any complications with assets in another country?
Yes, there can be. The best thing that you can do with foreign assets is to have a will in each country that you have assets. Now, usually you can only have one will at any one time. If they're in separate countries, you can make multiple as long as you refer to them in each will. So if you had a will here, you would say that it doesn't revoke your will in, say, Spain or France or whatever. You can cover the assets in a different country under a UK will. It is better, however, for tax purposes if you have a will from the country where your assets are, because obviously the setup there can be very different. So it's worthwhile having some advice in that country as well on a will there.
Great. Thank you very much indeed. I think that's been very comprehensive. We've had certainly some very interesting advice. If you've missed any of it, it will be coming up on our YouTube channel later on today or tomorrow, and you can recap any of the slides. And if you want Daniel Roberts' details at Poole Alcott Solicitors, please feel free to just drop me an email. Meanwhile, on the screen, you can see there we are having our question time. Just a reminder for that, that's on the 7th of October. Please feel free to book in on that, and should be a complimentary drinks and so on. That should be great fun for everybody. Again, thank you very much indeed to Danielle for giving us this talk, and I look forward to seeing you in person on the 7th of October. Thanks very much and have a great day.